When you apply to register a trademark with the USPTO, you've got to be aware that it isn't just the government that can make a decision which could block the approval of your application. Private individuals and private businesses can also insert themselves into the application process to cause problems for you. One of the ways that they can do this is by filing an opposition against your application prior to its approval in order to prevent its approval. Hey friends, welcome back to my YouTube channel. I'm so glad you're joining me today. I'm Faith Mitten, an attorney on a mission to simplify brand protection for business owners. On this channel, you will find tons of easy to understand, free and practical insight about trademarks to help you learn how to better protect yourself and stay on the right side of the law. Now, the trademark application process is pretty intense, as I talked about in my overview video, which I will tag here and link to in the description. Like I said in that video, the application process can take well over a year in many circumstances, even the ones where the application is ultimately approved and done so on a streamlined basis. Part of the reason why the application process takes so long is because there are strict legal requirements that every trademark application has to meet. And so the application has to be reviewed by an actual person, not an algorithm, to check off all the relevant boxes. But it's also important to be mindful of the fact that the USPTO is a government agency with limited resources. So although the examining attorneys at the USPTO do need to individually process each filing to make sure that it is eligible for approval, they won't do much independent investigation into the trademark applicant or the business to figure out whether there are other things that should prevent the application from being approved. Now, don't get me wrong, they will absolutely check their own databases to see if there's any conflicts that should prevent approval, like I discussed in my likelihood of confusion video, which I will tag here and link to in the description. But beyond that, they're really only going to look at really obvious reasons why the trademark application should be denied, such as if the trademark is merely descriptive or if the thing applied for as a trademark doesn't even really function as a trademark. But the USPTO doesn't always make the right decisions. It is an agency, but it is made up of humans who, like all of us, are capable of making mistakes and errors. So that's why there's a mechanism in the trademark application process that allows for private individuals or private businesses to speak up and point out if the USPTO has missed something and has allowed an application to get too far into the approval process when it really shouldn't have. This mechanism is known as an opposition. An opposition is essentially a lawsuit that is held before a special court known as the Trademark Trial and Appeal Board, or the TTAB. The TTAB's only job is to make rulings and decisions about disputes involving trademark filings before the USPTO. So they don't have any power to decide trademark disputes otherwise, like trademark infringement stuff. Their sole focus is on USPTO filings and disputes about them. And towards the end of the trademark application process, there is a 30-day window known as publication, during which anyone with standing and the appropriate grounds can petition the TTAB to deny approval of the application. In a trademark opposition proceeding before the TTAB, standing and grounds are related legal concepts, but they are distinct and they are both equally important to prevail in an opposition. Standing is about who can bring the opposition. The opposer has to have some skin in the game, some legitimate stake in the outcome of this application. So to establish standing, an opposer will need to show that they have some real interest in the application and that they could potentially be harmed by the approval of the application. This doesn't require proving actual harm, just that there's a possibility of harm to the opposer by the approval of the application, such as a likelihood of confusion between the opposer's trademark and the applied for trademark. The grounds for the opposition, on the other hand, refer to the substantive heart of the matter as to why the trademark application needs to be refused. Essentially, what did the USPTO miss? So some examples for grounds for an opposition could be likelihood of confusion, like I mentioned earlier, where there is concern that the opposer's trademark and the applied for trademark are confusingly similar. Mere descriptiveness may also be grounds for an opposition. In this case, the opposer will be arguing that the trademark should not be approved because it would give a monopoly over certain terms that everyone has the right to use to describe products and services or the companies themselves. And granting the application would constrain their ability to use those terms. Dilution is another one where the trademark opposer could say the approval of this trademark will weaken the distinctiveness of my famous trademark and make people think that there is some sort of connection or affiliation between this large famous brand and whoever has applied for this other trademark. Fraud on the USPTO is another biggie regarding grounds for opposition, where the opposer is essentially alleging that the applicant lied on their application in some meaningful way about their business or their trademark, and therefore the application shouldn't be approved. And there are many more grounds for opposition that I'm not going to cover here. But to sum up the distinction between standing and grounds, standing answers the question, do you have a right to be here? Are you minding your business, or are you trying to stick your nose where it doesn't belong? On the other hand, grounds for an opposition answers the question, what is the legal basis for the refusal of this trademark application? What specific legal requirements will the approval of this application violate? You need to have both standing and grounds in order to successfully bring an opposition against an application. So be mindful of that. But what does an opposition actually look like? Whether you are filing an opposition or you need to respond to an opposition filed against you, you have to remember that oppositions are real lawsuits. They are a little bit different from typical lawsuits in the sense that you probably are not ever going to go into a physical courtroom and confront the other party like you see in courtroom dramas on TV. These kinds of lawsuits are usually resolved by exchanging documents back and forth, whether that's pleadings, discovery, motions, briefs, extensions, etc. That being said, even with lawsuits that get filed in federal court, many of them don't ever see the inside of a courtroom. Most of them are settled outside of court, and the same is true for TTAB opposition proceedings. That's because few people actually want or need to litigate. There is significant time, effort, and money involved in litigation. And so if the parties can come to a compromise before a whole trial ensues, that is the most ideal option in many circumstances. But another way that these kinds of opposition proceedings can end is if one party doesn't respond to a filing that they're supposed to respond to, and then they lose the dispute by default. Yes, that is correct. Even though the TTAB is not like a traditional federal court, there are very real consequences to the filings that are made or which are not made there. So you can't ignore any oppositions you receive if you are serious about getting your trademark application approved. If you don't respond at all, like I said before, you lose by default and your application will be rejected. Similarly, if you are the one initiating an opposition, you have a responsibility to see it through to the end. So it's not enough to just make an initial filing and hope the TTAB agrees with you or that the other party just goes away. If the trademark applicant does reply to your initial pleading, it is your responsibility to take the next step, whether that is initiating settlement talks or starting discovery or whatever else your attorney advised you to do. Because if you don't take the next step, you essentially abandon your opposition, which means you've wasted everybody's time on top of wasting your own money in filing the opposition. And if there is a later dispute between you and this applicant whose application you tried to oppose, courts are not going to be very inclined to agree with you, because when you had the chance to speak up and fight the approval of this application, you dropped the ball. Be mindful too that it's not a good idea to rush into filing an opposition. You need to carefully, with the help of an attorney, evaluate the strength of your claims, because it is possible for the trademark applicant to counterclaim against you and take some action to invalidate your legal rights if there is some sort of weakness that they can exploit. So filing an opposition only makes sense after you have consulted with a licensed, knowledgeable trademark attorney. Well, it kind of depends on how contentious the proceedings are and what the parties' respective budgets are. If the parties can't come to a compromise, or if a compromise will hurt one party more than they would like, then they're going to continue fighting. And with various motions and extensions and all of that, This kind of fight can take years to resolve in some cases. But if the parties are able to come to a compromise, then it can take a few weeks or months to resolve an opposition. So basically what you need to know is that an opposition either way can result in serious delays in getting a trademark approved, in addition to significant expense. Remember that oppositions are essentially lawsuits, and just like all other lawsuits, costs can be extremely unpredictable and extremely high. Even if you're thinking about settlement, you could be looking at a minimum of 10 grand to 20 grand in attorney's fees, not to mention other expenses such as court fees, expert witness fees, discovery fees, and more. And obviously the cost will be much higher if you need to fully litigate the opposition. In that case, you're looking at 5 to potentially 7 figures in total costs. So the cost is definitely something to be mindful of when you are deciding whether to initiate an opposition or respond to one. Sometimes rebranding and filing a new application for a much more distinctive trademark is more cost effective and a better operational strategy overall than sinking time and money into fighting an opposition during which your trademark rights are up in the air and completely uncertain. But if you are the trademark applicant, does that mean you're free and clear and you never have to worry about somebody challenging your trademark registration? No, not necessarily. Even after a trademark is approved, someone with the appropriate standing and grounds can challenge your trademark registration, whether they petition the TTAB to cancel your registration or if they pursue you in federal court for infringement or something else. And remember, in federal court, the costs are higher, the judges are less experienced, so it's a lot more stressful than litigating before the TTAB. But the good news is, if you do manage to get your trademark registered, you can go into any of those disputes in a much stronger position than if you did not have the trademark registration. This is because having a trademark registration gives you something known as the presumption of validity, which means you don't have to do the hard work to prove you're entitled to your trademark registration. The challenging party has to do the work to prove that your trademark should be invalidated, and then and only then do you have to respond and do some heavy lifting to defend yourself. So that's why if you're really committed to the trademark that you have filed, and you receive an opposition and you have the budget to fight it, it can be a good idea to fight it, because if you are successful in defeating it and you get your trademark registration, you're in a much better position to handle any other trademark challenges or disputes that could arise on your business journey. Given the complexities of oppositions and trademark disputes, it is a really solid idea to hire a trademark attorney if you need help with this kind of issue. While I have summarized some things for you to consider in this video is just that, a summary, and a lot has been left unsaid. So be sure to consult and hire a licensed trademark attorney if you need help with a trademark dispute. And that's a wrap. If you enjoyed this video, I hope you'll give it a thumbs up. Be sure to subscribe for more trademark content and hit the notification bell so you never miss when I post a new video. If you have questions or thoughts to share, please put those in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.